This is one of those moments where I need you to slow down and really hear what I'm about to say, because what is unfolding right now almost never happens in American legal history. A former First Lady of the United States is on a direct path to being forced to testify under oath about her marriage, her living arrangements, her tax filings, and her personal connections to Jeffrey Epstein. Not in a memoir, not in an interview, not through anonymous leaks in federal court under penalty of perjury. That First Lady is Melania Trump. And here is the part that makes this moment genuinely historic. This is not a partisan attack. This is not opposition research. This is not speculation from unnamed sources. This is the direct and unavoidable consequence of a legal decision made by Melania Trump herself and her own legal team. A catastrophic, unforced error that has now stripped away the privacy shield powerful families rely on to keep their personal lives out of public view. Right now, a federal judge is presiding over a case that opens the door to questions no First Lady has ever been compelled to answer. Where do you actually live? Where do you sleep most nights? What do your tax returns say? What state do you claim as your residence? Do those filings match reality? And if they do not, which version of the truth have you been telling under oath? This case did not begin as some explosive constitutional showdown. It started the way so many Trump-related legal battles do, with a threat. A massive threat designed to silence a journalist, intimidate a critic, and end a story before it could metastasize. A threat so extreme, it carried a price tag of $1 billion, but instead of backing down, the journalist did something almost no one ever does. He fought back. He sued first. And in doing so, he walked Melania Trump straight into a legal trap that even a friendly judge may not be able to undo. What happens next matters far beyond this one family, because this case tests a simple but dangerous question. What happens when powerful people are finally forced to play by the same legal rules as everyone else? Stay with me, because this is just the beginning. Actually began because this did not start in a courtroom. It started with a threat letter, the kind of letter that has terrified journalists, publishers, and media companies into silence for decades. Back in October, veteran investigative journalist Michael Wolff received one of the most aggressive legal threats imaginable. A demand letter accusing him of defamation and warning of a lawsuit seeking $1 billion in damages. Not millions, $1 billion. The message was blunt and unmistakable. Retract everything you have written about Melania Trump's connections to Jeffrey Epstein, issue a public apology, or face total financial annihilation. The letter came from Alejandro Breto, a Florida lawyer who has quietly become a go-to legal enforcer for Donald Trump's orbit. This is the Trump legal playbook in its purest form. You don't argue facts. You don't debate evidence. You threaten overwhelming litigation costs and dare the other side to survive it. And most of the time, this strategy works. People fold. They publish humiliating walkbacks. They issue what Wolff himself once described as North Korea-style confessions. Or they simply go quiet and hope the storm passes, because fighting back against $1 billion lawsuit is usually career suicide. That is exactly why this case is so dangerous for the Trumps. Michael Wolff is not a blogger. He is not a Twitter commentator. He is a journalist who has already survived years of legal intimidation and emerged largely unscathed. He has written multiple best-selling books dissecting the Trump White House and exposing internal chaos Trump desperately wanted buried. So when Wool received that letter, he did not panic. He did not apologize. He did not retreat. Instead, he did something that flipped the entire power dynamic on its head. He went on offense, and that single decision is what turned a routine intimidation tactic into the legal nightmare Melania Trump is now facing. What happened next is the moment this case stopped being routine and became radioactive. Because instead of reacting the way the Trump legal machine expected, Michael Wolff flipped the board over entirely. He sued first. Let that sink in. Instead of waiting to be dragged into court under the weight of a billion-dollar threat, Wolff went straight to New York State Supreme Court and filed a preemptive lawsuit of his own. This is almost unheard of in modern media law, and it was a deliberate, calculated decision designed to do one thing above all else: force the dispute into daylight. In that filing, Wolff did not hedge. He did not soften language. He did not quietly back away from anything he had written. Instead, he laid out every single statement Melania Trump's lawyers claimed was defamatory and dismantled them one by one, methodically, clinically, on the public record. He explained why each statement fell into one of three protected categories. Either it was factually accurate and supported by documented reporting, or it was clearly opinion protected by the First Amendment, or it had been deliberately stripped of context by Melania's legal team to make it sound more scandalous than it actually was. But Wolff didn't stop there. He escalated. He accused Melania Trump and her attorneys of engaging in what legal experts call strategic lawsuits against public participation. SLAPP suits. These are not lawsuits designed to win on the merits. They are lawsuits designed to scare critics into silence, bleed them financially, and send a message to everyone else watching. Speak up, and this is what happens to you. By suing first, we'll force Melania Trump into a position she has spent her entire public life avoiding. Participation, discovery, rules, deadlines, judges, and sworn statements. This was no longer a backroom intimidation tactic. It was now an active legal dispute governed by procedural law, evidence, rules, and constitutional standards. The moment Wolff filed that case, the Trump legal playbook lost its greatest weapon, fear. And that is when Melania Trump's legal team made the decision that would change everything. A decision that seemed clever on the surface. A decision they thought would put the case back under control. Instead, it triggered the trap. Once Michael Wolff forced this fight into the open, Melania Trump's legal team faced a problem they are not accustomed to solving. They could no longer rely on intimidation. They could no longer rely on silence. They now had to choose a battlefield. And that is when they made a move that on paper looked smart. Rather than litigating the case in New York State Court, where Wolff had filed, Melania Trump's attorneys attempted to remove the case to federal court. This is a common tactic in high-stakes litigation. Federal courts have different procedural rules, different evidentiary standards, and in many cases, defendants believe federal judges are more predictable and more restrained than state court juries. But there was something else at play here. Something far more personal. Through the random assignment process, the case landed in the courtroom of Mary Kay Vissil, a federal judge appointed by Donald Trump himself. From the outside, this looked like a gift, a familiar name, a friendly bench, a judge with a documented history of rulings that had previously favored Trump-aligned interests. To the Trump legal team, this likely felt like control had been restored. A federal forum, a Trump-appointed judge, a chance to shut this down quietly before it turned into something far more dangerous. And for a brief moment, it probably looked like the gamble had paid off. But here is the part most people do not understand about federal court. You do not get there just because you prefer it. You do not get there because you like the judge. You do not get there because it feels safer. You need jurisdiction. And jurisdiction is not a suggestion. It is a threshold requirement. If you cannot legally justify being in federal court, the entire case collapses back to state court. Worse, the attempt itself can open doors that were previously sealed shut. By choosing federal court, Melania Trump's legal team unknowingly stepped onto a pressure plate built into the rules of civil procedure. One that does not care who appointed the judge. one that does not care about political loyalties, a rule that demands proof. And in the next phase of this case, that proof would come at a devastating personal cost. This is where Melania Trump's legal gamble turns into a full-scale disaster because federal court has one unforgiving rule that no amount of political influence can bend. If you want to be in federal court, you have to prove you belong there. The legal mechanism Melania's team relied on is something called diversity jurisdiction. The concept is simple and brutal. Federal courts can hear a civil case only if the parties are citizens of different states. If both sides are residents of the same state, the federal court has no authority to hear the case. No discretion, no workaround. The case goes back to state court. Period. Michael Wolff is a New York resident. That is undisputed. Which means that for Melania Trump to stay in federal court, she has to prove she is not a resident of New York. Read that again. Not suggest, not imply, prove. By attempting to remove the case to federal court, Melania Trump voluntarily put her residency status at issue. And under federal procedural rules, the moment residency is disputed, the opposing party gains an extraordinary right, limited jurisdictional discovery. This is the legal trap. Jurisdictional discovery allows Michael Wolff's attorneys to demand evidence, documents, and sworn testimony strictly for the purpose of determining where Melania Trump actually lives. Not where she claims to live publicly, not where press releases say she lives, where she lives in reality. And once that door opens, it cannot be half closed. This is not optional discovery. This is not fishing. This is mandatory process triggered by Melania's own filing. Wolff's lawyers now have the legal authority to send written interrogatories, issue subpoenas, and take depositions aimed squarely at one question that suddenly governs everything. Is Melania Trump a resident of New York or not? If she is, the federal court loses jurisdiction and the case collapses back to state court. If she is not, she must prove it with evidence that withstands sworn scrutiny. Either way, she must answer questions under oath. There is no privilege here, no special carve-out for former first ladies, no exception for political families. The rules are mechanical. They apply the same way to billionaires and ordinary citizens alike. By chasing what looked like a safer courtroom, Melania Trump activated the single procedural mechanism that exposes her private life to the harshest light possible. And the questions that flow from that single issue are about to get far more personal than her legal team ever imagined. Once jurisdictional discovery is triggered, this case stops being abstract and becomes intensely personal because the law does not ask where someone says they live. It asks where they actually live. And to answer that question, Melania Trump now faces a level of scrutiny that no First Lady has ever encountered. Here is what jurisdictional discovery really means in practice. Michael Wolff's attorneys now have the right to question Melania Trump under oath, not in a press setting, not through spokespersons, in sworn testimony where every word carries legal consequences. They can ask where she sleeps most nights. Not symbolically, literally, which address, which bedroom, how many nights per year. They can ask how often she stays at Trump Tower in Manhattan versus Mar-a-Lago in Florida. They can ask when she last spent the night in the same residence as her husband. These questions are not gossip. They are legally relevant to determining domicile. They can demand her tax returns, federal and state. Those documents do not care about public narratives. They state explicitly where a person claims residency under penalty of law. If Melania has claimed Florida residency for tax advantages while spending the majority of her time in New York, that discrepancy becomes explosive. They can request property records, lease agreements, utility bills, credit card statements, travel logs, anything that helps establish patterns of daily life, where groceries are purchased, where medical appointments occur, where personal staff are based, Residency is built from habits, not headlines. And here is the part her legal team cannot escape. All of these answers must be consistent. Consistent with tax filings, consistent with prior statements, consistent with any benefits claimed at the state level. Inconsistency is not just embarrassing, it is legally dangerous. Every answer Melania Trump gives in this process is given under oath. A false statement is not a PR problem. It is potential perjury, and even omissions can be scrutinized once documents start to contradict testimony. This is why jurisdictional discovery is feared by powerful defendants. It strips away image control. It replaces spin with records. It replaces denial with sworn answers. And Melania Trump walked straight into it. What began as a defamation threat has now turned into a forensic examination of her private life. And in the next phase of this case, one detail in particular threatens to blow the residency argument wide open: her son. This is the detail that turns Melania Trump's residency argument from fragile to potentially fatal. Because jurisdiction is not decided in a vacuum. It is decided in real life, and real life leaves paper trails. At the center of this problem is her son, Barron Trump. Barron Trump is currently a student at New York University, located in Manhattan. That single fact carries enormous legal weight, because universities do not just ask where a student lives casually. They require formal declarations of residency, and those declarations have consequences. At NYU, as with most institutions, there is a substantial difference between in-state and out-of-state tuition classifications. The financial incentive to claim New York residency is real, and the documentation used to support that claim is explicit. Addresses, duration of residence, parental domicile, tax information. So here is the unavoidable question now facing Melania Trump under oath. What residency was claimed for Barron Trump on his application and enrollment paperwork? If the Trump family claimed New York residency to obtain in-state tuition benefits, that directly undermines Melania's claim that she is a Florida resident for federal jurisdiction purposes. You cannot be a Florida resident in federal court while simultaneously representing yourself as a New York resident to a university. The law does not allow for convenience-based residency, and it gets worse. If Melania argues that Barron lives in New York independently while she resides primarily in Florida, that opens another line of questioning. Why does a minor child reside full-time in New York while his mother allegedly lives elsewhere? Who supervises him? Where is the primary household? Where are the daily routines anchored? Residency is not about mailing addresses. It is about the center of life where family life is based, where time is spent, where obligations are fulfilled. For years, reporting has consistently shown Melania Trump living primarily in Manhattan, shopping there, attending appointments there, maintaining a visible daily routine there. Proximity to Barron has always been cited as the reason. Now that same explanation threatens to collapse her legal position, because if Melania lives in New York to be near her son, the federal court loses jurisdiction, and the discovery that proves it becomes part of the public record. Barron Trump is not a party to this case, but his presence in New York may be the fact that makes Melania Trump's federal court strategy impossible to sustain. Here is the most damaging irony of this entire saga. Even if Melania Trump somehow avoided the worst consequences of jurisdictional discovery, even if every residency question broke in her favor, the underlying defamation case is still astonishingly weak. When you strip away the outrage and look at what Michael Wolff actually wrote, the legal foundation of Melania's claims collapses almost immediately. Defamation law in the United States sets a very high bar, especially for public figures. And Melania Trump is not just a public figure. She is a former First Lady. To win, she must prove that Wolff made false statements of fact. that he knew they were false or acted with reckless disregard for the truth, and that they caused measurable harm. Opinion does not qualify. Context matters. Documented reporting is protected. Now look at the statements her lawyers targeted. Wolf wrote that Melania Trump had connections to Jeffrey Epstein's social world. That is not speculation. It is supported by publicly documented facts about modeling agencies, social circles, and historical events. He wrote that she may represent a missing link in Donald Trump's relationship with Epstein. That is plainly framed as analysis and opinion, not a statement of provable fact. Opinion is constitutionally protected. He referenced Epstein-era social overlaps and introductions involving modeling networks. Those are verifiable elements of the historical record, including Melania's work with ID Model Management, an agency with well-documented ties to figures in Trump and Epstein's orbit. None of this is reckless fabrication. None of it is anonymous rumor. It is contextual reporting, layered with interpretation. That is exactly what the First Amendment protects, which raises the unavoidable question. Why take this risk at all? Why expose your residency, your taxes, your marriage, and your private life to sworn scrutiny in federal court to pursue a case you are likely to lose on the merits? This is why legal experts quietly describe this as malpractice territory. Someone should have stopped this. Someone should have explained the cost-benefit analysis. Someone should have said no. Instead, Melania Trump pressed forward, and now she is enduring the most invasive legal exposure of her life to chase a defamation claim that may never survive summary judgment. And in the next phase of this story, the question is no longer whether she can win. It is whether she can escape at all. At this stage of the case, the most dangerous reality for Melania Trump is not the questions she will be asked. It is the fact that there is no clean way out anymore. Every available option comes with severe consequences. One possibility is to voluntarily abandon the attempt to stay in federal court and ask that the case be sent back to New York State Court. But doing that would require admitting what would be obvious to every legal observer, that the removal was a mistake, a public, irreversible acknowledgement that her legal team miscalculated and triggered discovery they could not control. That kind of retreat is rare in high-profile litigation, and it invites even more scrutiny. Another option is settlement, but that door appears effectively closed. Michael Wolff has shown no interest in backing down. He did not sue first to quietly compromise. He sued first to force transparency, to establish precedent, and to put the intimidation strategy itself on trial. Settlement would deprive him of the very discovery that makes this case matter. Melania's team could attempt to limit discovery, arguing that questions about her personal life are overly intrusive. But federal procedural rules leave little room for discretion on jurisdictional disputes. If residency is legitimately contested, discovery must be allowed. Judges do not get to waive jurisdictional requirements out of sympathy or political alignment. That leaves the most likely outcome. The case proceeds. Discovery moves forward. Depositions are scheduled. Melania Trump sits down under oath and answers questions about where she lives, where she sleeps, how often she is in New York versus Florida, and what her financial and tax records actually show. Her answers are recorded, transcribed, preserved, and once those answers exist, they do not disappear. They become part of the litigation record. They can be referenced by journalists. They can be analyzed by investigators. They can be compared against public statements and prior filings. This is the nightmare scenario for a family built on narrative control. Donald Trump has spent decades using litigation as a weapon to intimidate critics into silence. But this time, the weapon backfired. The legal machinery he relied on to suppress information is now forcing it into the open. And for Melania Trump, the clock is no longer ticking toward victory. It is ticking toward testimony. When you step back and look at what is happening here, the significance goes far beyond one lawsuit or one former First Lady. This case exposes the core weakness of the Trump legal strategy that has worked for decades. It only works as long as no one fights back, threaten lawsuits, inflate damages, intimidate critics, drain them emotionally and financially. Most people retreat long before a judge ever gets involved. And because of that, the facts never have to be tested. The documents never have to be produced. The answers never have to be given under oath. Michael Wolff broke that cycle. By suing first, he forced Melania Trump into the one arena the Trump orbit avoids at all costs: a courtroom governed by rules rather than leverage. In that arena, power does not come from money or intimidation. It comes from evidence, from consistency, from truth. For Donald Trump, this is the nightmare scenario. Not because the defamation claims are strong. They are not. Not because the judge is hostile. She is not. But because discovery does not care about loyalty or politics. It cares about facts. Where do you live? What do your records show? Do your statements match your filings? Those questions cannot be spun. They cannot be tweeted away. They cannot be buried under threats. If Melania Trump testifies, her answers will become part of the permanent public record. If documents contradict those answers, the consequences expand instantly. What began as a defamation dispute turns into a credibility crisis, potentially a tax issue, potentially something far worse. And this is why this moment matters for everyone watching. For journalists who have been threatened into silence, for whistleblowers who were told the cost of speaking was too high, for citizens who were taught that the powerful never face accountability. This case proves something dangerous for entrenched power. The moment intimidation fails, the system flips. The rules apply. The questions come. The truth is demanded under oath. Melania Trump did not intend to create this moment, but she did. Through a single strategic mistake, she opened the door. The discovery process is just beginning. Depositions are coming. Documents will be produced. And when sworn testimony starts, there is no rewind button. We are not watching speculation anymore. We are watching accountability in real time.